All right, it looks like we are leveling off. So hello, everyone, and welcome to today's webinar. My name is Gail Schwartz with the Housing Alliance of Pennsylvania. Thank you for joining us for today's webinar titled Housing Law, Part 2. To let you know, this presentation is being recorded and will run approximately 90 minutes, including question and answer time. Additionally, please note that we are able to save the information in the chat feature. We will also send you a link via email to this recording in the next few days, as well as upload it to our YouTube channel and post it on our website. Attendees will be muted during the presentation. If you have questions for the presenters, please type them in the Q&A box in the bottom of your screen. If you have a logistical question for Housing Alliance staff, please use the chat feature. The chat feature should not be used for questions for the presenters. So with that, I want to hand it over to our presenter. I want to welcome back Kadeem Morris, staff attorney in the housing unit at Community Legal Services. With that, I give the time and the floor in the Zoom room to you, Kadeem.
Thanks, Gail. I'm happy to be back for part 2 of our presentation entitled Housing Law for Advocates. We're going to talk about emergent issues today, which should be really fun and really exciting, at least for me as a housing advocate. Hopefully everyone agrees in some way, shape, or form. So let's get started. I am sharing my screen, as I said, emergent issues and what you need to know. So we are really going to start, I think, at one of the most pressing issues in housing law. How do we avoid discrimination, both in leasing and in posting of ads around available apartments or units that are available for lease? So there is federal law that prohibits discrimination in housing, including rental properties on the basis of all protected classes. So it's race, color, sex, religion, nation of origin, disability, and familial status. So what does this actually mean in terms as a housing provider? It means that landlords should not use any of these above mentioned categories as a categorical exclusion for residents that they are screening, or you should not place an ad that particularly excludes one of these groups from housing, or basically says, I will not rent to you because of your race, your sex, your religion, your nation of origin, or disability, or your different ability, however we'd like to phrase that. So discriminatory practices includes placing all families in the same building or on the same floor of a building where multiple units are available throughout in multiple buildings. That's kind of placing all of people of the same familial status in like the same place to avoid maybe, let's say, noise or something like that. Falsely claiming that no units are available for rent because of one of the above reasons. So you might say, we don't have any units available, even though you're responding to a posting, but we're going to send you across the street to this other building that has lots of units available. That can be used as what's considered a pretext for like racial discrimination or nation of origin discrimination. And also using targeted language in an ad such as no Mexicans, Christians only, or able-bodied communities, or it can be said differently like Mormons only, or no disabled individuals allowed. And of course, refusing to make reasonable accommodations which are required by federal law when a disabled or differently abled resident requests them. Now, for the most part, most buildings at this point should be ADA compliant, but there are still some buildings in smaller homes because of when they were built that may not have been built in an ADA compliant manner. So that's just something to look out for. So something that we need to talk about, it's not actually a protected class or group of people, but HUD does actually have guidance on the use of criminal records. And what it really says is that any owner or manager that performs a criminal background check or uses someone's criminal history as a part of the approval criteria must ensure that there's no disparate impact of the use of this criminal background history on a particular group of people based on their race, nation of origin, or any other protected class. And disparate impact is defined as when a policy that will apply evenly to all people. So example, we're running your criminal background check. We're not admitting anyone with an arrest record. That is an evenly applied policy. It will pass the smell test for discrimination. However, it has a disparate impact on certain groups of people, particularly minorities, particularly some people who may be of different nations of origin, who may have more interactions with police for several reasons. It will probably also impact people with petty crimes for drugs or criminal activity and those types of crimes. If you are using it as a criteria to select someone for housing, you have to make sure that you're not categorically then rejecting a subgroup or protected class of people on the basis of that protected status. So violations will include using a blanket arrest records ban, ban on prior convictions of all prior convictions as a blanket ban for housing, use of criminal history related to non-housing specific misdemeanors or petty crimes. So if you're going to use someone's criminal record, you have to show that there is some relationship with the charge or criminal record matter that you are considering and housing. In Pennsylvania, criminal records can be both expunged and sealed. So that's something to be aware of when you are considering the use of someone's criminal record. Can this record be sealed? Can it be expunged? The burden is not on a landlord to expunge or seal someone's record, but it's just a type of crime and a consideration that should be used. If this is something that the state has determined as policy, should not be used or should not have an ongoing negative impact on an individual's right to exist or engage with services, then it really shouldn't be something that's being considered when being used as a criteria for housing exclusion. So what is expungement? Really briefly, under 18 PA CSA 9122, expungement is available for non-conviction, so charges that are withdrawn, dismissed, not prosecuted, or there's a not guilty plea. If someone goes into an ADR program, ADR is available for things like minor drug offenses or DUIs, summary convictions if the person has had no arrests after that for a period of 5 years, felony misdemeanor convictions if you are over 70 or have become free of arrest for 10 years. And when we think about that, I think the category of people that's often forgotten is those individuals who may be over 70 and for whatever reason, either because of change in finances or change in familial status, or new to the rental market and may not have been impacted previously by their criminal records, but are now trying to find new housing or being rehoused, and their criminal record from maybe 10 or 15 years ago, if not longer, are being used as a means to exclude them at this, I would say, the second coming of their life when they're trying to get housing. So that's just something to be aware of. So this is an example of these cases can be expunged, as we did say, cases that have either been dismissed, withdrawn, or null pros. So here you have a few charges such as prostitution, disorderly conduct, and criminal solicitation. All of these charges have been withdrawn or not prosecuted, essentially. So these can be expunged. The prostitution charge where there was a guilty plea, that can theoretically be sealed. It's just another way of clearing your criminal or history or background in Pennsylvania. So we're just not going to, those are things that should not really be considered or used in disqualification from someone who's from housing, unless you can show a direct relationship between the crime that you are considering and housing. So this is the first hypothetical, just to kind of make sure the expungement and discrimination concepts are kind of sticking in the minds of people or kind of making it home. All of the following are prohibited forms of discrimination except, and we can launch the first poll. I think it's a pretty clear answer. Hopefully people are on the same page that I'm on. Gail, I
While
don't know if you.
people are filling out that poll, I just have a couple of questions. So one question is, does family status protect to adult couples?
So I believe it should protect to adult couples. It's family status is not defined. There's no, I mean, there is something like the concept of the nuclear family, but the law does not specifically define how your family should be constructed, because that in and of itself could be an act of discrimination. So if there are two adult couples that are being treated differently because of their status as two adult couples, I assume that would come under the law. It would probably, the policies generally aren't directed at two adult couples, although I can see instances where they are used in that manner. It's usually directed as parents with children or single head of households with children is where the discrimination usually takes place, but family status may be a pretext for something else in the context where it's just two adult couples who are living together.
Great. And then another question is, in looking at the list of protected classes, is there any consideration for adding sexual orientation or gender identity to the list of protected classes?
So at the federal level, there is some case law where it has been found that sexual orientation is included in sex discrimination. So that is something that exists out there. There's no explicit protection for sexual orientation at this point, and it may get added in Pennsylvania. It may be added. Your various city ordinances may have sexual orientation discrimination protections, but on the state level, it does not yet exist.
All right. And are we good with the polls?
Okay. So most people said a designated senior living community, and that is 100% correct. I would say the one that I would say also is a tricky one is the use of non-expungible criminal records. If you were selecting that one, I think your thought process would be that there may be a reason why someone can show that the use of a criminal record is related to housing, but you'd have to show that relationship if it were challenged. But a designated senior living community or seniors only is per se discrimination on the basis of age or ableism, essentially. So let's keep going. So we're going to talk about reasonable accommodations. This also fits into the non-discrimination in housing category. So what is a reasonable accommodation? To put it in its simplest form, it's a change in a rule of policy or practice or service that is provided by a housing provider that may be necessary to provide a disabled person with an equal opportunity to both live and enjoy their dwelling. The accommodation must be necessary, it must not create an undue burden on the landlord, and it must not be a fundamental alteration in the services provided by the landlord. And it must also be related to the disability for which the accommodation is being claimed. So accommodations can be made for both physical and mental disabilities and are required both under the Fair Housing Amendments Act and the Americans with Disabilities Act. So there usually is some requirement for a medical provider to certify that the accommodation is necessary. The level of paperwork that is required is usually determined by the landlord and the tenant as they seek to negotiate through this process. I would recommend that if someone comes to you with a reasonable accommodation, and I think usually from when you do an application process, there are categories of people that you can pick out that may be eligible for a reasonable accommodation, such as people who get disability as a source of income. That is a flag in your mind that this person may be entitled to some sort of reasonable accommodation. That's not to say that they're the only category of people who are entitled to reasonable accommodations, because it goes for mental and physical disabilities that may not be readily apparent, and someone may be disabled but just not receiving that as a source of income. So just to kind of really drive this point home, we've got a poll that really says true or false. All of the following are examples of reasonable accommodations that do not place a significant financial burden on the landlord. As you remember, it must be necessary, related to the disability or condition that is claimed by the person requesting the reasonable accommodation, and not require an undue financial burden to the landlord. And these are just three examples. They're changing the way rental payments are made so that a mentally ill tenant who may not be able to go out of their unit or may not like interacting with individuals can have their family member or rent payee agency pay on their behalf, assigning a disabled resident a parking spot that is near to the entrance of their building so that they can park and not have to walk a long distance to their unit if there's a physical disability, and allowing a disabled resident to have a service animal where service animals are not otherwise permitted or there's a cost attached to having that accommodation. We can launch that poll.
And while people are filling that out, if we want to address a couple of questions, the first one is about a very hot topic in this space. Is there a federal distinction between medically necessary assistance animals and emotional support animals?
So I'm not aware of there being a federal distinction between medically necessary support animals and emotional support animals. I believe to get an emotional support animal, you have to get that animal certified by a medical provider that shows that you do need this animal for some level of support, and it's usually related to some medical condition, or I wouldn't necessarily call mental health a disability, or some issue that you are dealing with. And I think once a provider provides a certification that this person needs this animal to coexist or to navigate life in a pleasant way, it's not really up to the landlord at that point to make a determination as to whether or not the service animal is a service dog for someone who might be blind, or an emotional support dog for someone who might just have anxiety. I think those two things fall under the same umbrella category in terms of reasonable accommodations, and trying to parse through that in and of itself is really hairy territory to get into, and will run afoul of the spirit of the legislation, if not a clear violation of the Fair Housing Ordinance and also the Americans with Disabilities Act, because mental health is considered a disability generally, and we shouldn't be parsing through what is what at that point.
Right. And I don't believe people need to disclose the nature of their disability just because they are requesting an accommodation.
Yes, that's correct.
Okay, so it looks like with this, we have to break out each poll individually.
Okay. Okay, so that is true.
Yep. Do we need to get to the next poll?
I think just to save time, I will just say all of these are actually true. None of them actually place an undue financial burden on a landlord. I would say the service animal, if there's a fee attached to that, generally the requirement is that fee is waived so that there's no additional burden being placed on the tenant to have this. And the parking spot thing is pretty clear that if you provide everyone with parking, a reasonable accommodation is that for someone who is disabled or who might need to walk a shorter distance, you place them closest to the door to their building. Like usually there are handicap spots that are kind of close to the door, but if for some reason all of those spots are reserved and someone asks for an accommodation for that, that is well within the power of the landlord to do, and doesn't have any additional costs, and is relatively easy to like connect that to someone with limited mobility. Okay, so we're going to talk about rehousing in the COVID-19 world and kind of things that we should be looking for as people try to transition either to new housing or maybe stay housed where they currently are right now. So things that we should be thinking about is the existence of eviction moratoriums. There was a statewide moratorium There's a federal moratorium right now. Some cities do have their own eviction moratoriums. The availability of rental assistance through the the money came from the federal government, but it's being managed by the state. Restrictions on eviction filings that we put in place by the courts, and disclosure requirements in terms of things that landlords are required to let tenants know before they file an eviction. COVID limitations on someone making a speedy vacate, i.e. the unavailability of rental units, and illegal lockouts is still illegal. So that's just something to be aware of. So let's start with kind of things that landlords and advocates who are helping tenants to transition to new housing should really be looking for when you look at a lease or you're helping someone sign a lease. A good lease quite often clearly states the obligations of tenants and landlords very clearly and in plain language. So it will say the date at which the lease starts, the date at which the lease ends, what the rental obligations are, who's responsible for things like appliances, what appliances are provided, how repairs will be done, what happens if someone wants to break their lease, leave their lease early. It will clearly outline any late fees that are applicable. If there's a charge for things like exterminations or repairs, that will clearly be noted in the lease when you get it, and that's the model of a good lease. Also, things like clear deadlines and notice provisions. So it will say that if you are moving out at the end of your lease, you have to give 60 days notice. If notice is not given, then you are locked in for an additional year, at which point you can theoretically try to break your lease. And it will outline the process for that. It will outline the process for an eviction. Let's say your landlord is trying to evict you. It will clearly state if the landlord has to go through the eviction process to remove the tenant from the unit, you are entitled to, let's say, 10 days notice of an eviction before the case is filed. Also, if the landlord is trying to collect legal fees, that will be clearly stated in there in the lease, in that provision when it's put out. And it does not attempt to sidestep the court process or tell you that you are not entitled to go through court or it is subject to arbitration and mediation and not the court process. Now, there might be these programs available in various counties across the state where you can go to an arbitration or mediation if you would like as a first step before you go and engage in the court process, but you can't waive the court process. And of course, it will be ADA compliant, letting you know that you can request a reasonable accommodation. It will also have necessary disclosures such as lead law notices and notices about utilities to tenants, things that they can presumptively ask for and tests that can be done on units as necessary. And of course, a good lease always has a severability clause. I put this one in particularly for landlords who may be on today's training. That basically says that if there's a provision that runs afoul of the law, the rest of your lease is still enforceable to the extent that it complies with the law. Red flags are unenforceable provisions. Things that we should really look for are leases that attempt to waive court proceedings. You cannot waive someone's right to go before court. That is not an enforceable provision. The landlord-tenant law actually sets out the way that you can remove someone from a unit, and it's through a legal eviction or theoretically an ejectment process, and that cannot be waived. Waiver of the landlord's obligation to make repairs, that's called the implied warranty of habitability. The tenant's ability or right to pay rent is contingent on you providing a habitable home. That also cannot be waived. The waiver of security deposit return, that is not covered under the Landlord-Tenant Act. Is actually a separate law in Pennsylvania that governs the return of the security deposit, and the landlord cannot waive that right for a tenant. A tenant can waive their security deposit as a part of an agreement to move out of a unit, but a landlord can't waive that in a lease. Waiver of the landlord's duty to mitigate damages. If the tenant does move out early, now a landlord can request in a lease that, or state that a tenant is responsible for the full entirety of the lease. But if you were to take that tenant to court, let's say 3 or 4 months after they've moved out, the court will balance your obligation to mitigate damages, i.e. put the rental unit back on the market as soon as possible to get rent for it and mitigate your loss during that time when they assess any damages that are owed to you or unpaid rent by the tenant. So that is not a waivable right. And of course, late fees that generally exceed 10% of the landlords or the monthly rent, that I think is covered under the unfair debt collections practices ordinances that I believe is at a state level. So that's something to watch out for. You can't charge excessive late fees. You can set your late fees clearly and they can be agreed to. But when you get to court, if they're excessive, that's something that the court can adjust or throw out. And of course, provisions that allow a landlord to terminate a lease without notice, just on the basis of non-payment. Let's say a tenant is 1 month behind, and the landlord says, you're 1 month behind, your lease is over, I'm kicking you out. That is not an enforceable lease provision, at least if notice is required elsewhere in the lease. And of course, you can't waive the right to the court proceeding, so you still have to file an eviction and ask the tenant to leave or ask the court to remove the tenant if the court does not automatically, or if the tenant does not voluntarily vacate at that time. Okay, so we are now going to move to talking about the CDC eviction moratorium that is currently in place. It was put in place by the Center for Disease Control, and I know there has been some action in the courts about it, but for now it is still in place. So what is the CDC moratorium? It is a national moratorium put in place by a federal agency in response to cases of COVID, in recognition that there is significant public health risk for individuals that are forced to double up or rehouse during a pandemic. There are some jurisdictions that may have or have had stronger moratoriums that were in place. The CDC moratorium does not change that. It's just an additional protection that exists. And of course, it's been in effect since September 4th of 2020, and it goes through June 30th at this point in time. It's set to expire at that point. It does require renters to pay as much of their rent as possible, and all back rent would need to be paid by the time the moratorium expires for you not to be evicted through the court process. So the moratorium does not waive rent. It just gives you some protection until the end of the moratorium, at which time all of the rent that is owed should be paid to your landlord. And it applies to non-payment of rent evictions, non-payment of rent and other fees. So theoretically, non-payment of rent and late fees are the types of cases that will come under the moratorium. It does not waive the ability of a landlord to evict a tenant for a termination of term or a breach. And also there are these clear exceptions. A tenant can still face evictions for lease violations, including criminal activity on the property, threatening the health and safety of other residents, damaging the property or posing an immediate risk of damage to the property, violating building codes or health ordinances. Those are usually covered breaches, essentially, or violating any other contractual obligation other than timely payment of rent. So like having 10 people in a house where the lease clearly says that there are only going to be 2 people in the house, theoretically can be a health code violation depending on where you are, or it's a violation of a lease obligation. And of course, you'd have to file through the court process, and the court will determine whether or not this is covered. It does, or it should stop all phases of the eviction process, whether it is a lockout or a court filing. Some jurisdictions are allowing cases still to be heard where the landlord can file an eviction court and the case will proceed, but there's no lockout, or possession cannot be granted on the basis of non-payment of rent for the duration of the CDC moratorium. So you might get a judgment against the tenant, but it's not actionable through a order of possession until the moratorium expires. And some jurisdictions do also allow landlord to challenge the CDC eviction moratorium. So who does it cover? It covers all tenants in standard rental housing or private market housing. It covers tenants in HUD housing properties, mobile homes, land in and or tenants who live on land in the mobile home park. Tenants they are required to sign the CDC Declaration and send it to their landlord by a certified mail, text, and or email. This is not a presumed right. This is something that you have to affirmatively sign the paperwork to be covered by. So if someone has, or someone may have lost income through the pandemic and are eligible for the moratorium, but they haven't signed the declaration, if the landlord has sent them notice of the availability of this and they have taken no action, then theoretically the case could still proceed through the courts. So just so we're clear on the qualifications, it covers all adult household members earning less, the household income has to be less than $100,000. There are also qualifications that if you receive the stimulus check in one of the last 3 rounds, you're theoretically covered just based on your income. That's another way to prove your income. If you're unable to pay your full rent due to income loss or extraordinary medical bills or generally expenses related to caring for someone else through COVID, like funeral expenses that come up that often affect individuals who are on fixed incomes but have family members that they need to help. If you have used best efforts to obtain governmental assistance. So it doesn't require you to be approved for rental assistance, but you have to apply in good faith and seek to get that aid. And if you're likely to become homeless or are forced to develop live in close quarters, if you were to be evicted from your home. And of course, there is a promise or requirement that you will attempt to make partial payments as best as possible when you're not able to make full payments to your landlord. The order, or the most current version of this order, does not require your financial hardship to be related to COVID. It just requires it to have taken place within the COVID-19 window, which is being viewed as March 2020 through the ongoing period, at least through June of this year. And there's no requirement of proof, but it's often suggested or encouraged that if you're sending this to your landlord and you have proof readily available, you should communicate that proof to your landlord so you don't end up in a situation where your landlord is attempting to challenge the veracity of the allegations that are in the declaration. And of course, there are criminal penalties for the landlord who violates this agreement, and a tenant who theoretically submits a false declaration will be guilty of a crime of perjury, which is a crime that will be prosecuted on the federal level and not through the state system. So I've included here a copy of the most recent version of the CDC Declaration form, just so people can see what it looks like. And it's, as I said, these are the reasons why you would qualify. There's column A and column B. You must check that your income qualified or you received the stimulus and you have lost substantial household income or you've had increased expenses. And of course, you then go to the declaration page and it says that you understand that you are still required to make some sort of payment to your landlord or you may become homeless. Of course, it's signed under the penalty of perjury, which means that if you lie, that is something that is actionable on a federal level. I haven't heard of any cases where it has gotten to that point yet, but that's just something to be aware of. There might be different versions of this form because some courthouses do have the same form essentially just on the court's logo. So you might see something a little different, but this is basically what the form would look like. And it's available at the CDC website, or just a quick Google search for CDC Eviction Moratorium should bring up this form. And what are the limitations or risks that advocates should be aware of? Of course, informing the tenants about CDC protections. A lot of people still are not aware of that. And landlords proceed in cases without having notified tenants that the protections are available or despite the protections being available. And of course, the ability of someone to challenge the declaration in court and create a whole other process by which the tenant would have to verify. That's why we encourage, once someone is submitting the declaration, to include any information that you might have that supports your declaration.
I do want to clarify that starting May 5th, the Center or Consumer Protection Finance Bureau is instructing landlords who are proceeding with an eviction filing that they do have to provide the CDC in advance of that, the declaration to tenants in advance of that. So that's just a new development that has happened within the past week.
That is actually on the next slide, I believe. So
Okay.
we we talked about this briefly last week when we were doing the presentation, but this is a requirement under the Fair Debt Collection Practices that if a landlord is trying to theoretically evict someone for non-payment of rent or the payment of or the failure to pay a debt that is owed to the landlord, you must notify the tenant in advance that the CDC moratorium exists and that they may be eligible for it. And it says that if you are sending notice of an eviction, it has to be sent at the time that notice is sent. If notice is waived in the lease, it has to be sent at the time that the complaint is being served at a very minimum, and it must inform the tenants of their rights under the CDC moratorium. And a landlord cannot say or presume that a tenant is not qualified for this. So you have to send this out and give them the opportunity to respond before you go through with the court process. Now, if you file a complaint and a tenant sends you back this form signed, at that point, theoretically, you should withdraw the complaint because you do know that they're covered by the CDC moratorium. That is not necessarily required by every court, but that's just a best practice tip because you're required to do this in advance if you're trying to pick someone for a non-payment of rent. So just wanted to make sure we included that again, because that is a relatively new development. So just so individuals are aware, because this often comes up in the context where there are limitations on a landlord's ability to evict someone through the court process. Illegal lockouts are still illegal. And an illegal lockout is any eviction that does not go through the legal court process. It is illegal for a landlord to evict a tenant by changing the locks without a sheriff or a landlord-tenant officer, depending on your jurisdiction, using force or intimidation, turning off a tenant's utilities, removing the tenant's possessions and putting them outside on the curb, removing doors or windows from the house, boarding up a house, telling a tenant that they do not qualify for the CDC declaration and basically telling them that they need to move. Because of that, that's something that is that's a new thing, but a landlord is also not allowed to tell a tenant that they don't qualify if a tenant sends them a CDC declaration form or not send them a CDC declaration form on the basis that they assume that they do not qualify. And basically any attempt or any other tactics that are used to remove a tenant from a unit without going through the court process or pursuant to a court order is considered an illegal eviction. And I believe we have a quick poll just to reinforce this fact. It is a true or false question. And the question's statement is, any situation outside of a court-ordered eviction where a tenant does not leave or move out of a residence voluntarily is a illegal eviction or lockout.
All right, so while people are answering that poll, we do have a question that asks if the CDC declaration is available in other languages. I do believe on the CDC official website, there are versions in several other languages, as well as the National Low Income Housing Coalition also has numerous versions in many different languages of this declaration as well. So we can include links to that in the follow-up from today's webinar.
And I do believe if you're working with someone, if you don't have a language accessible form available, if you're working with someone, at the minimum, you should probably be able to use a translation service so that while you're explaining the form to them, there's an interpreter who can explain in their native tongue what it is. But I do believe it is available in other languages. Okay, I'm not sure who the 33 participants were that answered no to this poll, but I just want to reinforce that if a tenant is not leaving voluntarily or there's not a court order to remove the tenant from the unit, that is considered an illegal eviction. You can't waive the court process and you can't use tricks, intimidations, or any other tactics to remove someone from a unit. So the keywords there are voluntarily leave in, or a court has determined that you are entitled to possession, especially now that there is a CDC moratorium in existence and there's the requirements that landlords send this notice to tenants before they try to evict them. I would err on the side of caution and not attempt to encourage anyone to leave when they might be protected by any of these moratoriums or restrictions that currently exist. Okay, and just so people are aware, this is another reason why you should be cautious. The Attorney General's office is actually actively investigating and engaging in illegal lockouts. So if you are aware of someone who might be illegally locked out, or if you're helping a client and you're dealing with a landlord who might be attempting to use force or intimidation or any other tactic to force the tenant to leave the home, the 800 numbers there, the PowerPoint presentation will be included and it will have that in it. And you can call and the AG will attempt to mediate the issue and hopefully not need to file a case against the landlord. Hopefully the presence of the AG will encourage everyone to comply with the current restrictions or requirements on evictions. But of course, a tenant can always voluntarily agree to leave. That is not illegal. But if you use force or intimidation, that is illegal. So we're going to shift gears and talk about housing resources for victims of domestic violence. I think it builds very nicely on the last issue that we were talking about. So we're going to start by saying, what are some common issues that are faced? Of course, there's evictions on the basis of nuisance, police activity, or property damage. When a victim of domestic violence is attempting to be rehoused, there's often issues with credit, passing criminal background checks, or needing to escape an abuser and theoretically break their lease or transfer their subsidized housing voucher to a different project. And all of these have different levels of involvement for advocates. And of course, I would suggest there's a Pennsylvania Coalition Against Domestic Violence, PCADV. They're a wonderful resource and can provide you with all the help that you need if this is your first time or if you're unclear around what issues are. These are some stats. We don't really need to go through them, but I would say mothers with children, about 80% of them have experienced domestic violence, and half of domestic violence survivors have been homeless at some point in time. So that's just something to be aware of, that it is a pervasive problem. The laws that protect against domestic violence, there's of course the federal law, which is the Violence Against Women's Act, which provides some clear restrictions on things that landlords can or cannot do to victims of domestic violence. The Fair Housing Act, which provides or protects victims or members of protected classes from discrimination on that basis, and will prohibit indirect acts of discrimination that may attempt or have a disparate impact on a protected class, something like a eviction, someone for a noise violation. And of course, you can file a lawsuit or make a complaint to HUD if you are aware of any of these issues happening, or if you're dealing with someone who has been a victim of one of these violations. And of course, there's the Pennsylvania Human Relations Act, which prohibits discrimination in public accommodations against a protected group. And there may be local ordinance. I'm aware of one in Pittsburgh and one in Philadelphia, which specifically prohibits discrimination on the basis of someone's status as a victim of domestic violence. There might be more, but those are just the ordinances that I'm currently aware of. So the Pennsylvania Human Relations Act prohibits direct intentional discrimination against a protected group. Race, nation of origin, I think where it comes into play right here is that sex discrimination is prohibited, and it can prohibit policies that apply blanketly but may have a disparate impact on a particular group that is protected. So if there's a policy that says you get removed or you'll be evicted if your landlord calls the cops, or if police activity is reported at the property more than once, if that has a disparate impact on women, or then that policy is per se a violation of the Human Relations Act. And of course, we have another example here where the landlord never rents to women, and that is an example of discrimination, or also where a victim calls the police because of a disturbance that has happened with a boyfriend or ex-boyfriend, and the landlord seeks to evict them on the basis of that. Now, as of 2014, I believe in Pennsylvania, most nuisance statutes cannot be used to evict a victim of domestic violence because there's a state law that kind of addressed that issue, but it's just something to be aware of. That's something that will also be considered discrimination under the Human Relations Act. So the Violence Against Women Act protects applicants of subsidized housing from being denied admission for incidents or criminal activity related to domestic abuse, stalking, dating violence, or sexual assault. So this is particularly for individuals who may be in public housing or attempting to enter public housing where their criminal history or incidences of domestic violence, sexual abuse, or stalking or dating violence are being used against them. So generally, public housing, Section 8 housing choice vouchers, that someone gets a voucher to go out into the public market and find housing, like tech properties and city and Section 8 properties are all Section 8 project-based properties, which are housing that are often specifically set up for particular groups. There's often housing that's set up for seniors on the Section 8 or that voucher program. And there's also sometimes transitional housing for victims of domestic violence, where, believe it or not, criminal activity may come into play when a former partner realizes where someone lives. And of course, there are also, in addition to the federal law, there's city and state ordinances that may apply to these different types of housings also. So when to use these various laws as defenses: if a landlord files a complaint for breach based on excessive noise, disturbances, or police activity, a victim of domestic violence can raise the VAWA protections. If they are in subsidized housing, they can raise discrimination claims under the Pennsylvania Human Relations Act, and there might be city ordinances that are applicable. A landlord wants to keep the tenant security deposit as a result of them needing to relocate or move out prior to the end of their lease. That is something that's an unfair rental practice ordinance and can be actioned across most of the state. Additionally, if someone has a PFA or the court order showing that there was domestic violence and they're moving as a safety issue, this is an instance where landlords should not attempt to treat them differently than they would otherwise treat a male counterpart or whoever else might be living in the property. That can be viewed as pro se discrimination. And of course, if a housing authority denies one of your clients an entry into a unit or fails to approve their application on the basis of a criminal history with a former partner that is related to domestic abuse, stalking, or one of those other categories that we talked about, or a criminal record where someone was arrested because the police were called as a result of domestic violence and they were actually the victims of domestic violence, those are all things that are actionable on the VAWA. And where a landlord is trying to evict someone where they ended a relationship with an abusive partner, they're trying to essentially protect themselves or move out, and the abuser was a co-tenant and they're asking that that person be removed from the lease. If the landlord tries to evict the tenant as a result of that, that is a violation of the Pennsylvania Human Relations Act, and also can violate city ordinances or state ordinances where they're applicable that protect individuals as victims of domestic violence. So usually documentation is not required unless someone is trying to terminate a lease early, where you have to show a PFA or police report or written certification from a provider who is trying to help you through this process. Subsidized housing owners may require or request some sort of proof of the incidence of domestic violence, but HUD does provide a self-certification form and allow for third parties such as the court or police reports to verify. Medical professionals and attorneys also verify that someone was a victim of domestic violence. So hopefully that is clear. I would say err on the side of caution where there's an assumption or belief that there has been domestic violence. You should not attempt to evict someone And if the tenant tells you that this is an issue, you should probably try and connect them with help before trying to use the court process to remove them from the property. So to keep things rolling, we are going to talk about emergency rental assistance, which is rental assistance that is now available to tenants and landlords to help them with their unpaid rent, which I think is welcome news to everyone on this call. What is ERAP? The Emergency Rental Assistance Program was created as a part of the Consolidations and Appropriations Act of 2021, $25 billion allocated across the state. Pennsylvania got $847 million as part of the first initial disbursement. There's actually ERAP 2.0, which was a part of the American Rescue Plan, which has Pennsylvania expected to receive another $760 million to the state for rental assistance. So that is a huge chunk of money. So for anyone who is working with a tenant who has fallen behind or is aware of a landlord trying to evict a tenant for non-payment of rent, we encourage them to apply for ERAP first and see if the landlord-tenant relationship can be salvaged. And if it is, then everything is paid up and we're good to go, I believe. So who is in charge of ERAP? ERAP is being run through the Department of Human Services. Most Pennsylvanians can use the Compass app, and people who are receiving any sort of public benefit might actually already have a Compass account, or if you are participated in the healthcare marketplace, you might also have an account. How much assistance is available right now? The statute requires that under ERAP, you can get 12 months of back rent if you owe 12 months and 3 months of forward rent. That's on the ERAP 1.0. And if there's additional funding, there might be additional funds that are made available at the discretion of the county administering the funds. How is ERAP different from other versions of rental assistance programs that might have existed? This does not tie your financial hardship to COVID. Your financial hardship just has to have taken place during the COVID-19 period, which is March 2020 ongoing. And also, most importantly, ERAP can provide utility assistance for persons who are responsible for and behind on their utility bills. You have to owe your utility. There's no forward-going utility assistance, but if you owe utility debt, it can be covered under ERAP. So this is a two-part hypo. I guess it's a bit wordy, but just to make sure that comes home for everyone. Jane has been unemployed since March of 2020. She receives unemployment compensation, but that is only enough to cover her household expenses. The last time she was able to pay rent was June of last year, June 2020. Her monthly rent is $1,000. Additionally, Jane's landlord has filed an eviction against her, and she has found a new place that she cannot afford to move. First question is, how many months of rental assistance is Jane entitled to? And is Jane protected by the eviction moratorium from evictions? So hopefully people can do the math. I will say if people can pick 11 or 12 for the sake of time, just so you're clear, it's more than 5.
So while people are answering that question, I just wanted to see, I have one question here. If the tenant is required to pay for certain utilities and they do not, and those utilities are shut off for lack of payment, is the landlord required to get those utilities turned back on?
No. So if a utility is in a tenant's name and the utility is terminated or turned off for failure to pay that bill, the landlord is not required to pay for that service. If the bill, however, is in the landlord's name and the tenant pays the landlord for that service and doesn't pay, and then it gets shut off as a result of that, that can theoretically be considered an illegal eviction or lockout. You're allowed to collect that debt through the court. So that's just something to be aware of. I would say the utility companies have just restarted lockouts again because they were just given permission by the Public Utility Commission to do that for regulated utilities, but most aren't actively doing shutoffs, and there is ERAP available for utility bills. And most people picked 12 months. And I would say at a minimum, it's 11 months. You can get 12 months because you're entitled to ongoing assistance for that 3-month period. So everyone's kind of on the same page. And is Jane protected from eviction? I hope that's clear to everyone, but we can take another question while people fill out that poll.
Yeah, we do have a couple of just questions about ERAP in general. Anybody who's looking for how to get connected to ERAP in their community, they can go to the Compass website and they just click. There's a drop-down bar. You just click on your county. It will either give you the administering agency's name, or if it's a county that is getting their funding directly from the state or exclusively from the state, you can also complete your Compass application online there. So the best place to start to find out what's right for your county is the Compass website. There can be some differences from county to county and how they administer it. Federal legislation and state legislation allows for landlords to apply or start the application on behalf of their tenants, but the tenants are going to need to participate in that application and provide some verifying information as part of it.
Yeah, and I believe that there might be a form that is given to the landlords for the tenants to kind of fill out if the landlord is the one submitting the application. So really quickly on the Jane poll, most people are correct. Jane is protected from eviction because she's receiving unemployment compensation, which means she has lost income in the COVID pandemic period, and her household income, although it's not stated at this point, we can assume it is under the $99,000 threshold at this point. So glad that we're on the same page with that. So just so we are aware of how people are eligible for ERAP, the household has to be responsible for paying rent on a residential lease. There must be an arrearage that accrued after March of 2020. The income threshold is 80% of AMI, which is actually pretty high. And one or more household members must be receiving unemployed benefit, had a decrease in income, increase in household costs, or other financial hardship. Because during the pandemic or because of the pandemic, and of course, there must be risks of housing instability or homelessness, which is kind of presumed in the COVID-19 period, unless you can randomly or rapidly relocate to another unit that's available to you, then you theoretically be covered by the eviction moratorium. So this is something that I just want to make people aware of, with the caveat that it is done differently in almost every county. So the county specific information that Gail did say is available through DHS's website is something that you should check out. The ERAP can also cover other expenses related directly or not linked to the COVID-19 pandemic. So we're talking about relocation expenses such as security deposits, first and last if you're moving to a new property, reasonable late fees, hotel and motel costs if you have moved out of a unit because you had fallen behind. That is something that can be theoretically covered. And internet service costs can theoretically also be covered. Now, I'm not aware of any counties in Pennsylvania that are covering for internet service fees, but there is a federal program that was just announced that I'm sure there'll be information forthcoming on that through the FCC where people can get assistance for their internet bills. But the important things to know that these additional expenses, the availability of them does vary by your county, and it is at a minimum, they're required to pay your rental arrears and pay your utility arrears, but this additional money or like assistance with relocating varies by your county and may not be immediately available. So if you're working with someone, I would caution them that yes, you may get this benefit. I would say if you have a contact in your county, reach out to that contact, that they may be able to make an exception based on facts and circumstances and provide that additional assistance based on budgetary constraints. So as Gail and I think we also talked about, you can apply through Compass. There are paper applications that are available in several languages. I believe county assistance offices, to the extent that they are open, might also be able to help you with that. What you really need is IDs for household members, income verification or verification of no income, a lease or evidence of your rental or arrearage payment. So if you pay by check and you have an oral lease, I believe there's a process where your landlord can attest to the fact that you live there and there's some oral lease. Other information confirming monthly housing costs or other costs that are not covered, such as utility bills or whatever other expenses have caused a change in your income if they exist. And Hypo number 5, I think, is pretty simple. It says all of the following are covered expenses under the Emergency Rental Assistance Program, except, and we can take any questions that exist while people are completing that poll.
So again, another couple clarifying questions about ERAP. Can tenants apply for both rental and utility assistance, or do they need to choose one or the other? It does cover both.
It does cover both. I would say where the situation might get tricky is that if a tenant is paying, if the utilities are in the landlord's name and that is included in rent, a tenant should list the rent portion including the utilities if that's what they're paying every month. If you don't include that, then you can't go back and later try to apply for that if you apply for rent or payments to your landlord and your landlord attests that this is what your rent owes. So to the extent that you're applying for utility debt that's not in your own name, include it as a rental payment because that's essentially what you're paying to your landlord.
Okay, and then I have another question here. Can a landlord evict some tenants that are in a group living arrangement, such as a specific family member within a property, but not the entire family?
So that's complicated. I would say where that is usually permitted is where there's like a domestic violence situation that has happened where someone is removed based on a court order or evidence of domestic violence. If you go to court and you evict someone from a household and a sheriff shows up, the sheriff usually is not going to say, you specific person, you have to leave. They'll say, household, you have been evicted. So I would say if you're trying to do that, unless they all have separate units, which is not what I'm hearing, that's a bit harder to do because if the family is still there, theoretically, they can always return to the property, which is an issue that's often run into. So I would say don't do that unless you're getting the entire family to leave because the sheriff will likely put out the entire family. And just to follow up on that poll that was done really quickly, everyone did pick that food is not covered, and that is really what's not covered. There's increased SNAP benefits for most people, and people who aren't traditionally eligible can also apply, but food will not be covered under ERAP, but everything theoretically could be covered. And we did say utility debts are covered for those who were not immediately following along on that train. So this is just a slide with some information for advocates who are working with tenants who may have fallen behind on their rent. What to do if you can't pay your rent due to COVID, of course. Ask for a payment plan, ask for a waiver of late fees if their landlord's charging you late fees, make partial payments, ask your landlord to apply prepaid rent to any missed month or months that may be out there. Fill out the CDC Declaration form and provide it to your landlord if you know that you're behind on rent and you're trying to get caught up. Apply for ERAP with your landlord, or if your landlord may have applied for you, fill out the paperwork so that the payments can be made. If you need to move out or if you're agreeing to move, ask your landlord to schedule a move out date. Ask for a waiver of the early lease termination fees if you still owe some months on your lease. Take photos of your property so that there are no issues with your security deposit. And most importantly, return your keys, because until you return your keys, you're still in legal possession of the unit and your landlord theoretically cannot lock or change the locks at that point unless there's some agreement that they can use as proof, and that's a harder burden. But once you return your keys, then that's easy for your landlord to do. And of course, if you make an arrangement or agreement, get it in writing, just so that everyone is clear as to what the terms are and what obligations are placed on parties. And we've included this information for strategies to prevent utility terminations for people who might have utility debts that have accumulated during the pandemic period. Of course, there are assistance programs that are available. CAP is called Customer Assistance Programs for Utility Customers. It gives you an income-driven bill if you have lost income or if your income is particularly low. There's hardship funding, which are like one-time grants that utilities pay out to customers who have fallen behind on their bill and may not otherwise be eligible. There's LIHEAP, which is the Low Income Home Energy Assistance Program. That just ended, but there might be some additional federal dollars that are coming out. So there's supplemental funding that may be available. Of course, a utility customer can always request a payment arrangement either through the utility or the commission. There's a winter moratorium that's coming up. It starts in December of each year and runs through about April or May. Households below 250% of the federal poverty limit cannot be terminated during that time period. If your service is off, no guarantee that you can get it back on. But if you're carrying a utility debt at this point and you can get caught up, that is something to be aware of that may be available to you later in the year. Med certs are for medically vulnerable households to prevent their utility services from being terminated during a pandemic now where finances are harder, or just generally at any point in the year. You don't need to use med certs when there's a winter moratorium because that covers most people. Protections for customers with PFAs or victims of domestic violence. You can't be terminated because of someone else's debt, even if you're living in the household. When the debt accrued, you can get a longer payment arrangement than a typical 24-month payment arrangement. And of course, you're entitled to additional notice as a victim of domestic violence when a utility is trying to terminate your service. And most importantly, if the debt is more than 4 years old, it cannot be used as a basis for termination. So that is just something for advocates to be aware of as you work with vulnerable households who might be facing utility terminations. I would suggest you have them apply for ERAP, and then all of these programs can be used to cover whatever is left if there's something left after the emergency rental assistance, or just as an ongoing mitigation for eviction or utility termination prevention. And of course, here's the hotline for LIHEAP, the number for the Public Utility Commission. And this is PULP's utility hotline, the Pennsylvania Utility Law Project that works a lot on these issues, and they may be able to help your client or help you as you work with the client. So this is kind of just a quick utility hypo. It's a true or false question, just to make sure we're all aware of what's happening in the utility spaces. It says all of the following are available forms of utility assistance for tenants, and it's emergency rental assistance program, LIHEAP, and customer assistance programs. So it's true or false, and while you answer that, I will check on any questions that Gail may have at this point.
So I have a question. This is actually my own question. So if utilities can't charge or shut off for debts that are older than 4 years, can they deny new service for debts that are older than new years? Like you're a tenant, maybe you've moved back to the area after 5 years, you have arrears from 5 years ago, and that utility, can they say, no, we're not going to turn it on until you pay these arrears?
So I don't know the answer to that question. My inclination is no, but I would say the people at PULP are probably better equipped to answer that question. It has happened where someone has been denied service on the basis of old utility debt that may be older than 4 years. If they are going to deny service, they might require you to get on a payment plan before they give you service. And that's something that also the Utility Commission can help address. It seems like our poll was kind of, I think, formed incorrectly. It should have been a true or false. The answer is that all of these are actual available forms of assistance for utility customers who might be behind on their debt. It's just customer assistance programs are available all year round. LIHEAP is usually during the winter moratorium months, so December to March or April, depending on when the moratorium ends. And of course, emergency rental assistance. So long as there are funds and dollars available and you have utility debt, you can apply for that. So I apologize for the way that poll was formatted. But I think everyone, whatever option you picked was correct. All of the options were correct. Okay, so now we are in our Q&A period. So if there are any remaining questions that people may have, we will be able to tackle them at this point.
All right, so the first question is, if a tenant moves out without giving a forwarding address, does the tenant forfeit the 30-day notice for the security deposit and other charges?
So no, if a tenant moves out without sending a forwarding address, then you send the notice to the last known address, even if that's your address or the address of the unit that they were previously in, because the assumption is, or the hope is, that the tenant will forward their mail through the post office. And at the very minimum, even if their mail is not forwarded, you can prove that you sent the notice to the last known address. So even if a court decides that they're entitled to the return of their security deposit, the court cannot assess damages against you because you did provide notice to the tenant with the most current address that you had.
Great. And then can you just clarify for utility costs, can ERAP be applied to any debts that were accrued prior to COVID?
So no, ERAP covers the COVID period. So it would have to be debts that are accrued after March of 2020. That's kind of the way the funding is being distributed, both for rental assistance and the utility assistance. I would say if there's debt that occurred prior to COVID, customer assistance programs are often an option, and utility-based payment arrangements are often an option for people who have pre-ERAP debts or pre-COVID debts.
Great. And do you have any advice for tenants who are applying for ERAP and landlords are not being responsive in submitting their information?
So I would say if a tenant is applying for ERAP and the landlord is not being responsive, you should submit your application. Go ahead and submit your application. I believe there are processes that are being set up where if the landlord does not want to participate, the tenant may be able to get that payment directly after a few tries with the landlord. But the first step is to submit your application and let your landlord know that you applied, and make sure the county or whoever is handling your application has a way to contact your landlord, because that's going to be their first outreach to the landlord. And then if the landlord does not respond, there's a process by which that can be handled. It's not an automatic denial. Okay. Yes.
So I will say currently, there's a lot that was left up to discretion of ERAP providers and how they were going to handle some of these sort of straightforward situations. There was guidance that was issued by the US Treasury that is really strongly encouraged and explicitly stated an expectation that direct-to-tenant payments are to be offered to folks who are applying where landlords are not necessarily participating or cooperating. But again, this was something that was literally released last week. So what is your advice for somebody who may be in a county where they haven't quite figured out the direct-to-tenant options, but they're in this kind of limbo? Should they be contacting legal services in the area, or what is something that people can do if things are not working so well?
So I'd say there are two things. If your landlord's going to try and evict you, they will likely have to send you that CDC moratorium notice and information about available assistance. And if you apply and they fail to complete the application, that will be something that you can use in court to say, I have applied for all of the eligible assistance. My landlord has refused to participate, and I'm waiting on the county to decide whether or not I'm entitled to that payment. Of course, I do encourage people to speak with legal services where available if you can get someone to help you navigate that process, because court paperwork can be very intensive. And if you don't file something correctly, it may get thrown out. But that's just to make you aware. Your landlord has to send you that CDC notice and should also then apply for rental assistance with you. But at the very minimum, you should apply for rental assistance. But if you end up in court, you can say, I have applied, sent the information to my landlord, but my landlord has not complied, and I am waiting. Maybe there'll be an appeal process at your county level at later after the payments are paid out, and if there's funds left over, where you can then appeal and say, I've been denied because my landlord did not apply, and then you can get payments issued to you. But at very minimum, you should put in your own application so that you're in the system, and whatever gets worked out by your county, you'll then get notified that something is available for you.
Right, and I will share with everybody on the webinar today that in last week's guidance, there was a process laid out for counties to do their due diligence in trying to connect with landlords. I think it's 3 contacts within a week's time, something like that. So some time does need to pass for counties to try and get the landlord to cooperate. But again, if you're somebody who is in limbo, contact your local legal services. Last week, during our last webinar, actually, there was a big announcement in regards to the CDC moratorium. You did touch on it a little bit, but again, there was this ruling against the moratorium. Can you maybe explain to folks why, even though a judge ruled against the moratorium, it's still in effect?
So last week, there was a decision in Washington, D.C. in the district court that basically said the CDC overstepped its power by putting this moratorium in place, but the federal government applied for a stay of this ruling. So basically that means that the judge's decision is stayed and not put in force. So the moratorium still exists, and there's filing and litigation that will take place on whether or not the moratorium will still be in place in the future. But as of right now, the stay was granted. So the court's decision is not being enforced on that. And of course, there have been a few other decisions like this around the country, but the DC circuit, just because of the way it's positioned, has a little more persuasive power than some circuits. But right now there's a stay of that order's enforcement until there's ruling and briefing on the issue. And the federal government can of course appeal above the DC circuit, but for now there's a stay while that has been put in place.
Great, thank you. And then going back to late fees, and somebody asked, is a $5 a day late fee enforceable?
So $5 a day for 30 days, 5 threes are 15. That seems to be $150 a month. I guess it won't be charged for the whole month, because I mean, maybe it is charged for the whole month. I would say, depending on what your monthly rent is, if your monthly rent is something like $600, then you might be getting to the point where your late fee is considered excessive. But if it's $5 a day starting at day 5, and then it goes and then that gives you maybe 25 days at $5 a day, which I can't do the math on that, which is maybe like $125. That may not be so bad. But when you start getting to more than 20% of the rent, or if your late fee is like $20 a day, that is clearly excessive, because then you collect more than the rent that was actually owed. So that's the way you should think about it.
So if somebody's gone 3 months without paying rent because of COVID, and there's been this charge of $5 a day, so that would be potentially
so if it's 3 months, 450, it'll be measured against each month's rent. So it's not the $450 late fee itself is it won't be a $450 late fee, it'll be a late fee of $150 each month. And if it's reasonable for 1 month, then it'll be reasonable for 3 months, essentially.
Okay. And then it seems like different communities tend to have a different approach to handling different aspects of this crisis. So can you maybe explain why there could be a difference between how a holdover situation or how the CDC moratorium is being enforced differently in Allegheny County versus Blair County versus Philadelphia versus Lackawanna?
So that is a difficult question. I would say there are different courts and different districts throughout Pennsylvania, and there was a Supreme Court order at one point that basically had an eviction moratorium in it. That order has since expired, but different counties and some cities within counties have taken proactive action through their legislator. I know, like, Pittsburgh has a moratorium, Dauphin County has its own moratorium, and that's basically a result of advocacy by several agencies within the county, realizing that this is an issue and it will have an impact, maybe based on population density and several other reasons as to why the county has responded differently. I would say there are also home rule charters that are in play that determines how much ability a city or county may have to make its own rules. But I think the CDC moratorium attempts to address all of that various variations by putting in like a standard by which most Americans should be captured. And if there is something additional in your home city, home state, or home county, that is in addition to the CDC moratorium. The CDC moratorium does not really replace it. But I can't say it's because a county doesn't care about the issue. It's often advocacy from various agencies and groups such as the Housing Alliance that are working in various spaces that results in these sort of preemptive or additional protections being put in place in counties across the state.
Great, great. And then I think we have time for one last question, and this is going to be a fair housing question, but what are the consequences if you discriminate against somebody?
So there are financial penalties that are attached. You can also, if you receive federal assistance, you can also lose federal funding for the property. So like if a Section 8 property is discriminating against a tenant in violation on the basis of one of these federally protected classes, then they can lose the federal funding that comes through HUD for that property and no longer be qualified as a Section 8 property receiving that funding. There is also the ability to the tenant can file a complaint and also a federal lawsuit against you, and you can be subject to civil penalties, usually monetary penalties for those types of violations. And I think that's the most significant penalty that will come from this. Like if you're found to have discriminated against someone in housing, the court can assess damages against you as the housing provider who has discriminated. And that varies based on the seriousness of the discrimination. Or if you are pervasively putting blanket ads out there that says no Section 8, no Mexicans, like those are forms of discrimination that are readily accessible. And the financial penalty is the greatest penalty that you'll suffer as a result.
Excellent, excellent. So thank you. I want to thank you for this two amazing presentations on, all of the complexities that come with landlord-tenant situations and the nuances to the laws that really impact and can shape and affect those relationships. Of course, I should have done this at the beginning of the presentation, but I got to do a little bit of a disclaimer. Today's presentation was strictly for education purposes. It is not meant to be taken as legal guidance or legal advice. If you have a specific situation that you have encountered, whether it is you personally as a landlord or a tenant or as an advocate working with a tenant, please reach out to legal services so that you can get the best legal advice for your specific situation. And in these last couple of moments, I do want to make a little bit of a pitch to everybody on today's webinar. We in Pennsylvania just received our first disbursement of the second round of emergency rental assistance. So this was funding that was awarded to the state as part of the American Rescue Plan. The legal process for making sure that this funding gets to communities as quickly as possible is that legislation is going to have to pass through the General Assembly. With that, what we would like to ask of all of you is to make a phone call after today's presentation. We're going to send a follow-up email to all of you, as well as everybody in the Housing Alliance membership and on our email list, asking you to contact your legislator to do two things. With the first emergency rental assistance program, there was a cap that was put on administration fees at 5%, even though federal legislation allows for 10%. So we've been hearing from communities all across Pennsylvania that this is making it really, really hard to get assistance to people as quickly as possible. So we are hoping that you will call your legislator and let them know that we would like them to remove that cap from the first program, and that we are asking them to also create the second program without any additional requirements and caps, so it can as closely mirror the federal program as it was originally designed. We believe that this is the best way to make sure that it helps the most people. This is a program, it doesn't just help one or the other, it absolutely helps both landlords and tenants together, and it helps keeps our neighborhoods stable. So this is a really, really great program. It's already done some really, really amazing work. We do need to make sure that resources continue to flow as quickly as possible and get to the communities as quickly as possible and are as flexible as possible so that they can be as effective as possible. Beyond that, we also have some additional events coming up. So on June 10th, we are going to be continuing the eviction prevention conversation. We have a virtual forum talking about the 5 strategies communities can adopt to prevent eviction, and our keynote speaker is going to be Peggy Bailey, Senior Policy Advisor on Rental Assistance from HUD, along with amazing state and local leaders from across Pennsylvania to really talk about what we can all collectively do together to prevent eviction and the harm that it causes to tenants, the harm that it causes to landlords and to communities as a whole. Also, we do have another webinar on May 20th that's coming up that is going to be talking about increasing resources for the development of more affordable housing through state housing tax credits, both at the federal and state levels. So with that, it is now 1:30 on the dot. I just want to say thank you one last time to Kadeem Morris, who gave us a really, really great presentation. I know we didn't get to everybody's questions, but we will address any lingering questions in follow-up materials. Copies of today's presentation, recording of today's presentation, slides, everything will be sent out later this week. So thank you all. Thank you, Kadeem, and everybody enjoy the afternoon.
Thanks for having me.